Thank you, Mr. Chairman, members. I want to start off by saying that I'm about to present a very different perspective on this situation than I believe I'm aware of has been presented in courts or anywhere else. First, I don't dispute the governor's authority to issue an emergency declaration. I didn't dispute that before the Supreme Court ruling on it. I'm not going to dispute or debate the public health emergency and any necessity or measures that the executive branch has taken to do what he believes is in the best interest of the public health. Not going to dispute that. What I am concerned with, and let me just start off with some questions. What would you say is the purpose of the Louisiana Administrative Procedures Act?
That's a very broad question. Can you be more?
Well, I mean, generally speaking, what's the general intent of the Administrative Procedures Act? There's a few things.
It is designed to provide a framework for how administrative agencies conduct their business and conduct and regulate industries and prosecute.
Okay, and regulate industries. Okay, what are some of the provisions within the APA that provide the safeguards to the public for promulgating these rules and regulations on businesses? What are some safeguards? Public meetings, right?
Sure.
Yeah, there's a process, yes, right? We're experiencing it right now.
Yes, sir.
We're experiencing it right now. And so in light of that, and I've done a tremendous amount of due diligence to be able to have the understanding and come up with a very clear conclusion. What rules has your agency promulgated pursuant to the APA, whether they were promulgated via emergency rule or promulgated via the regular normal rule process with respect to the regulatory actions that have been taken by the agency?
We promulgated no rules, sir.
Okay, you've promulgated no rules.
No, sir.
And members, the Fire Marshal's office agency has not promulgated any rules. No executive branch agency has promulgated rules with respect to how they are regulating businesses with respect to the public health emergency. It's not been done. Now, we just promulgated rules. Obviously, we had an issue with a couple provisions on the several page document of rules that you presented. Mm-hmm. You stated, as is clear, that the rules are necessary to regulate that process. Now, as was testified, and I'm going to tell you, look, this is a difficult conversation for me to listen to people who are losing their life savings. And I mean, look, I get it. I've been there. Okay. And so these are some of the words that were used to describe. And now these aren't businesses who are has to express that the government should be involved in their life or they should get out or anything like that. These are people begging for reasonable regulatory provisions. Mention operating without being in fear. See, that's the problem. If you've got a license with the ATC, or if you're a business owner and you've got, the state fire marshal and the ATC are the biggest sticks that you can threaten business with. There's no bigger stick. Maybe LDH if you're a restaurant. Okay. Other than that, there's no greater sticks. And so the threat of enforcement, the state fire marshal, I chair Audit Advisory Council, and in testimony, zero enforcement by the state fire marshal has been taken. ATC, you stated 50 something?
51.
51. Now, the next thing that was mentioned is the inconsistencies, right? Things change. Executive orders change.
They do.
Right? Do you believe that the fact that the governor issued an executive order, which, if we're creating parity, the legislature has delegated its authority to in the emergency declaration process to create executive orders or proclamations that have the force and effect of law? It clearly states that. Do you believe that the governor issuing an emergency declaration negates your requirement under the law to promulgate rules?
I do not think, if I thought that rules were necessary in order for the agency to fulfill its obligations as directed by the governor, we would have done so.
See, that's the thing. To fulfill its what? Say that one more time, that last part.
Fulfill its obligations to carry out the dictates of the governor's.
Okay. So I thought we were supposed to follow the law. Did the governor say you don't have to promulgate rules?
He did not. No,
He didn't.
No, sir.
It's not in his order. There's no suspension of those provisions. It doesn't exist.
No, sir.
And so I am absolutely, and look, I've tried to be very patient in this process. I have received more backlash from certain groups or communities that exist on social media for my delay in response or engagement in trying to bring balance to this. And I have made every possible effort to communicate with this administration and over the entire process. And the courts at the recent ruling, the legislature did the petition. I won't even get into that. But the reality is the executive branch has unequivocally failed to follow the law and promulgate rules, even if they're emergency rules, pursuant to the Administrative Procedures Act for the carrying out of the executive orders that he's created, which I'm not even debating that the legality of them. We'll assume they're absolutely perfectly legal, right? And so how is a business owner supposed to know what the rules are? And see, I'm going to quote you. Sorry.
You can paraphrase.
No, okay. It says you with respect. You were talking about enforcement. You said it's only a small percentage of the bad actors who quote resist the rules that are required to be followed. Something like that. Mm-hmm. What rules are you referring to?
I am referring. I passed out rules and regulations to you, right?
What rules?
If you're going to ask a question, please allow me.
I'm sorry. I'm looking for the document.
Okay.
Okay.
All right. So our website is updated every time there is a change.
Yep.
Every time that there is a change, we print up documents like this, pass them to our agents, and our agents visit locations in order to educate permit holders, right? Mm-hmm. Now, you can make a distinction whether or not this is a rule that has gone through the process of rulemaking, or these are rules and procedures that are drawn up in order to address whatever the changes are at that time. They both serve the same purpose in this regard, and that is you let and you communicate to the permit holders as to what it is that they need to do in order to be compliant at this time. Okay,
so someone's license is on the line, right?
Yes, sir.
And you draft a document that's akin to a memo. Mm-hmm. That has had no public process input, no oversight opportunity or capabilities whatsoever, mm-hmm. and that equates to a rule. So it just so happens, we have the APA. Let me read what the definition of a rule is for you. Definition of a rule. And for reference, members, it's Title 49, 951, 6. Rule means any agency statement, guidance, any agency statement, guide, or requirement for conduct or action exclusive of those regulating only the internal management of the agency and those purporting to adopt, increase, or decrease any fees imposed on the affairs, actions, or persons regulated by the agency, which has general applicability and the effect of implementing or interpreting substantive law or policy, or which prescribes the procedures or practice requirements of the agency. Rules include, but is not limited to any provision for fines, prices, or penalties, the attainment or loss of preferential status, and the criteria or qualifications for licensure or certification by an agency. A rule may be of general applicability, even though it may not apply to the entire state, provided its form is general and it is capable of being applied to every member of an identifiable class. So that's what a rule is.
That's one definition of a rule. Yes,
it's
sir.
the definition of rule in the APA.
In the APA, that is the definition of a rule. As I explained in my previous answer, there is your formal definition of a rule, and I suggest to you that these are rules that are put out by the agency in order to ensure that there is consistency in regulation and understanding throughout the industry. Now, you can agree as to whether or not we can.
So could you have done that with what we?
Sir, please.
Okay.
Please.
I apologize. I apologize.
Respectful. I know we passionately
absolutely
are advocating our issue, but I don't think it's fair for.
It's
you
not.
To ask a
I
question
apologize.
and not allow me to answer it. And just because I said that, I can't remember what I was going to say.
You were comparing
So
the
please,
rules.
Yeah. So what I was going to say is we can have a definitive disagreement as to whether or not you feel it is necessary for us to go through the formal process of a rule. I'll give you that. I don't. The administration doesn't. My legal staff doesn't. But to say that the only rule that is valid from the agency's perspective are ones that are done pursuant to the APA I don't share the same opinion.
Okay, yeah, let me ask you. You mentioned that it's not the administration's position. Have you been instructed not to promulgate rules?
I have not, no, sir.
There's been no communication from the executive branch to not promulgate rules of any kind, emergency or otherwise?
No, sir.
Okay, good to know. We just went through a process moments ago to promulgate a list of rules. In your opinion and estimation, is it even necessary to do that, or could you have just issued one of your little memos right there?
I think the distinction between the rules that we have discussed previously today and what's going on here is that the formal rules are intended to be in place long term, not be changed, not be altered without a formal process, and represent the guidelines that are applicable, again, for the long term. Everybody in this room will testify or give anecdotal evidence that it has been necessary in terms of responding to the COVID epidemic to change the rules and go backwards and forwards and determine what's appropriate and what's not appropriate. And I do not think that a formal rulemaking process is conducive to allowing that to occur and allowing that to occur quickly. Look how long it took us to get on the docket for the two rules that we had previously. Can you imagine doing that every time that there was a change in circumstances related to COVID?
Of course, there are the emergency rule procedures.
There are, yes, sir.
Right, that bypass all of that. Mm-hmm. I would argue that you are operating under a legislative role in the rules and the enforcement that deviate from what the law says is under normal scenarios, and also the outside of the normal rulemaking things with respect to the emergency stuff.
I disagree with you that I'm acting in the legislative capacity. Separation of government in terms of executive branch, judicial branch, and legislative branch indicates. I've indicated previously that we work for the executive branch, we work under the governor's direction, and I am following his instructions with respect to what is being communicated to permit holders.
Do you have an obligation to do what the governor tells you to do, or to do what the law tells you to do?
Serve at the pleasure of the governor, sir.
So, and this is a genuine question, right? Employment and all. So, if you have a clear understanding of what the law says on any situation, and the governor tells you to do something different, you're going to just do what the governor says.
First of all, the governor would never ask us to do anything that was illegal. and it has never asked me to do anything.
Well,
illegal.
legality is obviously subjective to a degree.
And I mentioned previously in this testimony that if I felt it was necessary or a legal requirement, then that is the route we would have taken. I don't think it's necessary.
Okay. So, members, and I'll email this document to you later because this is a learning journey. It's from the Louisiana Law Review, Volume 68, Number 4, Summer of 2008. It's the Louisiana Administrative Law, a Practitioner's Primary. And it goes into some detail with regard to what constitutes an unconstitutional delegation of legislative authority. We are the policymakers. It's our role. The governor, executive branch role, just executes what we put in law. So, Civics 101. And there is a longstanding Supreme Court test from the late 50s, I believe, it referred to as the Schwegman test, that has been used many times as the standard for determining whether or not the legislature unconstitutionally delegated its legislative authority to the executive branch. Now, with respect to the emergency procedure, or the Public Health Emergency Act and the Emergency Disasters Act, all that, I question whether a couple of the prongs are met. I'm going to assume that they are. I'm going to read what the law review condenses as the three prongs of the Schwegman test used by the Supreme Court. Number 1, contains a clear expression of legislative policy. And of course, this is all operating under the Emergency Procedures Act, or the Emergency Acts, Public Health Emergency as well. So it contains a clear expression of the legislative policy, prescribes sufficient standards to guide the agency in the execution of that policy, and is accompanied by adequate procedural safeguards to protect against the abuse of discretion by the agency. So, and then I'm going to forward down later in the document, it refers to a separate case where the Supreme Court weighed in on the Administrative Procedures Act as absolutely, it says, in reaching its conclusion, the court relied heavily on the fact that the legislature provided significant, quote, procedural safeguards against arbitrary administrative action by expressly stating that the secretary's promulgation of rules must be in accordance with the Louisiana Administrative Procedures Act. Specifically, the court found that the provisions of the Louisiana Revised Statute sections, blah, 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 which provide for oversight of the rulemaking process by the legislature and the governor, rendered the defendant's argument of unconstitutional delegation to be invalid. So in this entire process, what we have here is the legislature's absolute inability to provide any oversight on executive orders and based on the authority provided in statute for the governor to issue these things. And by bypassing the APA, and trying to force businesses to comply with the Willy-Nilly Act instead of the Administrative Procedures Act, what we do is we create a level of hostility in our community, where instead of trying to work together as these gentlemen have testified, and the lady has come and testified, trying to work together to all bring about the same common good for public health and in our communities. Instead of doing that, one branch of government using borrowed legislative authority is issuing orders where no process to safeguard the checks and balances required in our Constitution in the creation of any policy or regulation is being adhered to. And it's just your opinion, and I appreciate that. Now I'm going to suggest this because I'm not aware of any court cases yet. So anybody, you might want to grab this, your pencils and jot this down. Revised Statute 49-963, judicial review of validity or applicability of rules. E says, Upon a determination by the court that any statement, guide, requirement, circular, directive, explanation, interpretation, guideline, or similar measure constitutes a rule as defined by RS 49-951-6, which I read earlier, and that such measure has not been properly adopted and promulgated pursuant to this chapter, the court shall declare the measure invalid and inapplicable. It shall not be necessary that all administrative remedies be exhausted. So I would suggest that every business owner feeling like they are being unlawfully regulated upon without proper rule making having occurred may look to the courts and not argue with the governor's executive authority, not argue over petitions, but argue the fact that this executive branch has absolutely unequivocally failed to follow the law as to promulgate rules and regulate the industries that they're threatening to enforce upon. And in conclusion, Mr. Vice Chair, see, if this is not a requirement, then we don't have the three prongs. Then it is an unconstitutional delegation of legislative authority. If this is not required. Now, I'm going to tell you why no rules have been promulgated, because they don't belong as permanent rules, number one. They belong as emergency rules. But to the legislature and the Emergency Procedures Act only requires one oversight committee, one chamber, to kill an emergency rule. And there is no executive override of the termination of an emergency rule by one oversight committee. That's why we haven't seen one. That's why we haven't seen one, because we don't want accountability. We want to claim we have the public's best interests at heart, but we're willing to step over the law and the constitutional requirements of to utilize the borrowed legislative authority. And I find that to be a tragedy. I don't care how good the intent is. We have to follow the law. And our businesses, the people who have their livelihood, their entire life savings invested and dwindling, are tied up. And they don't deserve that a proper rule be promulgated, either through emergency process or regular, where they have a input, where they can actually come and testify and present their concerns, and where the legislature can perform our oversight role like we just did. I believe we owe it to them. I believe the Constitution requires it. So this is just the beginning of future conversations on this subject. Thank you, members, for your patience.
Thank you, Representative Ivey.